Welcome to Sriram's IAS. The topic for today's discussion is anti-defection law. The original constitution did not contain any provisions regarding the anti-defection law. The 10th schedule was introduced by 52nd Constitutional Amendment Act in the year 1985, contained provisions relating to the anti-defection law. So what is anti-defection law? The phrase Ayaram Gayaram became popular after Haryana MLA Gayalal shifted his party thrice in the same day in 1967. So the anti-defection law soughts to prevent such political defection due to rewards of office or other similar considerations. The 10th schedule lays down the process by which the legislators may be disqualified on the grounds of defection by the presiding officers of the legislature, that is both parliament and state legislatures, based on a petition by any member of the house, based on a petition by any other member of the house. So the 10th schedule lays down the process. So what about the grounds of defection? A legislator is deemed to have been defected if either he voluntarily gives up the membership of the party or disobeys the directions of the party leadership on an oath. This implies the legislator defying the whip on any issue can lose the membership of the house. Defying, that is abstaining or voting against. This law applies to both parliament and state legislature. So let us try to understand what are the provisions of the 52nd Constitutional Amendment Act. So the 52nd Constitutional Amendment Act, the original constitution did not make any provision for anti-defection law. So the 52nd Constitutional Amendment Act 1985 added the 10th schedule of the constitution, which contained provisions relating to the anti-defection. Okay. So this 52nd Constitutional Amendment Act had made changes to the 4 articles, that is 102, 101 and 102 relating to the parliament, that is vacation of the seats and the grounds for disqualifications of the members of the parliament, and 109, 190 and 191 relating to the state legislature, that is vacation of seats in the state legislature and grounds of defection, okay, relating to the state legislature. Okay. So disqualification of whom? Both members of the parliament and state legislature, that is MPs and MLAs, on the grounds of defection from one party to other. So 91st Constitutional Amendment Act 2002 has strengthened the anti-defection law, that is, it limited the number of ministers in the Union Council of Ministers and State Council of Ministers, and the disqualification of a member as a minister if he is disqualified on the grounds of defection, and also it has removed one of the provision of the 10th schedule. Okay, it has repealed one of the provisions of the 10th schedule, that is anti-defection law. So let us find out the provisions of 91st Constitutional Amendment Act 2003, that is regarding the Union Council of Ministers. The total number of ministers, including the Prime Minister, in the Central Council of Ministers shall not exceed 15% of the total strength of the Lok Sabha. Regarding the State Council of Ministers, the total number of ministers, including the CM, in the State Council of Ministers shall not exceed 15% of the total strength of the Legislative Assembly of the state and shall not be less than 12, including the CM. So this is regarding the Union and State Council of Ministers, that is the number of ministers in the Union Council of Ministers, including the Prime Minister, shall not exceed 15% of the total strength of the Lok Sabha. And regarding the State Council of Ministers, the total number of ministers, including the CM, shall not exceed 15% of the total strength of the Legislative Assembly of the state and shall not be less than 12, including the CM. So, what about the disqualification as a minister? That is, a member who of either house of the parliament or state legislature under Article 75, that is regarding the parliament, and 164 regarding the state legislature, of any party disqualified on the grounds of defection is also disqualified as a minister. So a member who is disqualified, member of both parliament and state legislature under Article 75 and Article 164 of any party, if he is disqualified on the grounds of defection, he is also disqualified as a minister. So he cannot be a minister. And also a member of either house of the parliament or house of the state legislature belonging to any political party who is disqualified on the grounds of defection shall also be disqualified to hold any remunerative political post. And the provision of the 10th schedule, that is relating to the anti-defection law pertaining to exemption from disqualification in case of split by 1/3 of the members of the legislative party has been deleted. Okay. So the provision, there is an exemption. An exemption was provided by the 10th schedule, that is anti-defection law, that is in the case of a split by 1/3 of the members of the legislative party, the members will not attract anti-defection law. So that exemption, that is exemption from disqualification in case of split by 1/3 of the members of the legislative party, has been deleted. So what about the provisions of anti-defection law? Provisions of the anti-defection law, that is members, grounds of defection, that is members of the political party. A member of the house belonging to any political party becomes disqualified for being a member of the house if he voluntarily gives up his membership of such political party, or he votes or abstains from voting in house contrary to any direction issued by his political party without the permission, obtaining prior permission of such party. Such act has not been condoned. Condoned means accepted by the party within 15 days. That is, he is defying the orders of the party whip, that is disobeying the directions of the party leadership. That is, he votes or abstains from voting in such house contrary to any direction issued by his political party without obtaining prior permission of such party, and that act, that is his abstaining or voting against in the direction, has not been condoned, accepted by the party within 15 days. So what about an independent member? An independent member after election, can he join a political party or not? If he joins any political party, does it attract anti-defection law? Let us find out. So the independent member becomes disqualified to remain a member of the house if he joins any political party after the election, after such election. So an independent member cannot join any political party after the election. He has to remain independent. In case if he joins any political party, he is disqualified on the grounds of defection. What about nominated member? Nominated members, can they join any political party? Or if they join, whether they attract or disqualified on the grounds of defection? Let's find out. So nominated members become disqualified from being members of the house if he joins any political party after expiry of 6 months from the date on which he takes on his seat in the house. That is, he may join any political party within 6 months of taking his seat in the house without inviting disqualification. So a nominated member, after getting nominated, he can join any political party within 6 months. So he is not disqualified on the grounds of defection. After 6 months, if he joins any political party, he is disqualified on the grounds of defection. Okay. So what are the exceptions? Exceptions. So the exceptions are, one of the exception is merger. Okay. Merger by 2/3 of the members, they accept to the merger. Okay. So a member goes out of his party as a result of a merger of the party with another party, a merger takes place when 2/3 of the members of the party have agreed to such a merger. So, in case of a merger, when 2/3 of a merger, when a member goes out of the party, and for the merger to happen, or the condition is 2/3 of the members should accept for the merger. Then the members leaving the party and joining another party, and the members staying with the party. Okay, so they are not disqualified on the grounds of defection. That is, it is an exception. And also, a member after being elected as a presiding officer of the house voluntarily gives up the membership of his party or rejoins it after he ceases to hold the office is also exempted. That is, the presiding officer of both the houses of the parliament or state legislature, after getting elected as the presiding officer of the house, if he voluntarily gives up the membership of his party or rejoins after he ceases to hold the office, is also exempted from disqualification on the grounds of defection. So, who is the adjudicating authority? A question of defection, who decides the question or disqualification on the grounds of defection? Okay, so any question regarding the disqualification arising out of defection is to be decided by the presiding officer of the house, that is, chairman in case of Rajya Sabha and speaker in case of Lok Sabha. Is there any time limit? No, there is no time limit for him or her to decide such a case. Okay, so the presiding officer is the final authority to decide on the question of disqualification, and there is no time limit for such decision. Okay, so the decision of the presiding officer, that is chairman in case of Rajya Sabha and speaker in case of Lok Sabha, is final, and it was not subject to the jurisdiction of any court. But the Supreme Court in 1993 in Kyoto-Holan case has ruled that the final decision or the decision of the presiding officer is subject to judicial review on the grounds of being mollified and perverse. Okay, so Supreme Court in Kyoto-Holan case 1993 declared finality of the decision of the speaker under 10th schedule as unconstitutional and open to judicial review on the grounds of being mollified or perverse. Okay, so rule making power. Who makes the rules under the anti-defection law? Okay, regarding the disqualification on the grounds of defection. So, the presiding officers of the house is empowered to make rules to give effect to the provisions of the 10th schedule, and all such rules must be placed before the house for 30 days. The house may approve, modify or disapprove. Okay, so the presiding officer makes the rules, and he places, all the rules are placed before the houses for 30 days, and they may approve, modify or disapprove. So what about so when does the presiding officer take a complaint, okay, regarding defection? So the presiding officer can take up a defection case only when he receives a complaint from the member of the house. Only when he receives a complaint from the member of the house. So before taking the final decision, the presiding officer must give the member against whom the complaint has been made a chance to submit his explanation. He may also refer the matter to the Committee of Privileges for inquiry. Hence, defection has no immediate and automatic effect. Okay, so the presiding officer gives a chance for the member against whom the complaint has been given to submit an explanation, and he may also refer the matter to Committee of Privileges for inquiry. Hence, defection has no immediate and automatic effect. So, this is regarding the anti-defection law. Thank you.